Good evening, everyone. Tonight is a special regular session of the South Kingstown Planning Board. The date is Thursday, October 10th, 2024. The time is 6:32 p.m. The first item on our agenda is roll call. Peter DiStefano, Susan Axelrod, Joe Murphy, Robin Pothier is absent. Liz Karp is absent. Caper Wilson, present. And Maria Mack is here. Our next agenda item, and just for clarification for members of the public who are here this evening, we have one item that is for discussion within the planning board, and then the following item is a public hearing, just so that everyone is clear on this. So our first agenda item is request for extension of conceptual master plan approval, major multi-household land development project, 571 Main Street. Request to extend conceptual master plan approval for a 36-unit residential development and associated site improvements originally approved on November 13, 2014, later extended on December 13, 2022, and again on November 28, 2023, located at 571 Main Street. Is there anyone representing the applicant? Evening.
Attorney Matthew Landry on behalf of the applicant, 571 Main Street. Roland Fiore for 571 Main Street. Before you is a request for an extension of the applicable deadlines to the master plan approval for the 571 Main Street property. For reasons that I'll discuss during the public hearing on the next item, the original master plan approval was the subject of a settlement agreement between my client and the town during the original permitting phase for this that began, I think, in 2014, 2015 for the property. Before you on the second item of tonight's agenda is a proposal for a modification to that existing approval. The modification plan or application was submitted in February of this year, and as was just indicated, there were two prior extensions to this approval given. The original settlement agreement was entered into in January of 2020, and the extensions were given from that period forward. During the initial hearings and permitting process for the modification on this master plan approval, there were some discussions about extending the time for making a decision under the current application for a modification, and I believe I stated on the record that the applicant was certainly agreeable to doing that and allowing TRC review in the special meeting that is being held this evening in consideration of also extending the deadlines that are applicable to the existing master plan approval. So respectfully, we're asking for an extension of the existing approvals so that the board can hear the modifications and the changes on the existing approval that are being proposed. And again, over the process since February, we noted that for the record that we would extend the decision deadline for the current petition in conjunction with the existing approval so they could move together. We think that makes the most sense.
Thank you. I think it would be helpful for the board, as well as the members of the public, to hear from legal counsel so that it's clear what our authority is, what our decision can or cannot be, and what the ramifications of that might be.
Thank you, Madam Chair. So, as was alluded to in the applicant's presentation, this is an application for master plan approval that was originally filed back in 2014. It was appealed and the subject of litigation against the town. Ultimately, the town council decided to settle that appeal by agreeing that the developer could have a master plan application, as was originally proposed in the plans that are in your packet. So that master plan application was just like any other master plan, was vested for 2 years once approved. After those 2 years expired, by statute, they have a right to two automatic 1-year extensions just by by requesting those extensions from the planning board. They've received, the original 2 years have expired. The 2 1-year automatic extensions have been received by the applicant. So at this point, the statute provides that further extensions may be granted for good cause shown. So it's a very broad standard that allows you to grant a further extension beyond the automatic 2 1 years and the original 2 years if the applicant makes a showing of good cause. So that's the first consideration that you have before you tonight is, can they show good cause, to your mind, to extend this master plan approval beyond the current deadline where it's set to expire, which I believe it's set to expire in December at this point. If your answer to that question is no, then for practical purposes, that ends the inquiry. If your answer is yes, they've shown good cause and you grant an extension, there is the second item on the agenda, which is a public hearing. It's a request to change the approved master plan. And the changes that you've also seen in your packet involves a change in the areas of ingress and egress and the internal circulation of the project. So it's before you tonight rather than being approved administratively because it's what's considered a major change. And a major change, the review standards for considering a major change is the same standards that you would apply when first considering to approve a master plan. So I think the decision tree before you tonight is step 1. You reach item 1 and you decide, is there good cause for extension? If you decide there is not, that's the end of the inquiry. If you decide that there is, you grant the extension. Then you go on to step 2, which is the extension going to be for a modified plan, or is the extension going to be for the originally approved plan? When you consider whether to grant a modification, you could grant it simply as requested by the applicant, or you could grant it with some changes or conditions, like you could do with any approval to a original plan. Or ultimately, you could say, no, we're not going to grant the changes, we're going to grant you an extension, but it's going to be for your original approved plan.
And can you explain how the fact that there was an agreement previously, how that impacts procedurally what this board would do with either the previous plan or potentially a new plan?
So the terms of the agreement that were reached with the council, and obviously the developer's attorney can correct me if he disagrees, but ultimately they just determined that they would apply for and get approval for a master plan with certain conditions in it, but they did expressly say in that settlement that the master plan would be subject to the same procedure for changes to the master plan as would apply to any other master plan, and would also be subject to the same expiration period as any other master plan. So with regard to your consideration of this, you consider it just as you would any other master plan.
Thank you. Questions from board members?
Madam Chair, just for a point of clarity, and we have our counsel here as well as the applicant's counsel. I believe the request for the extension is specific to extending the previously approved plan developed by Dupree. Your kind of rendering and site layout was done by Union Studios. Mm-hmm. So I'm not aware of any proposal to ask for an extension of anything other than that.
Just for a point of clarification, that's correct.
If I may, if I understood what counsel said, the first question is there good cause shown for an extension? So that's the issue that I think we need to address first.
And its extension of the previously approved plan.
Correct. And then we can look at, if that's extended, then we can consider modification.
Yes.
So, Madam Chair, that's correct. So, obviously, there's been a number of years removed from the initial permitting application that came in that resulted in litigation with the town and a settlement agreement that ultimately came in 2020. There have been a number of changes in the law. There was a pandemic in the interim. The most important part of this request for modification from my client is with respect to the integrity of the home and making some significant, what we feel are improvements to the existing approved plan that reduces density, increases some of the setbacks while also being respectful of the conditions that were laid out in the settlement agreement. So, the good cause element of this, I think it's prudent for the board to hear the modification request because there are a number of improvements that have being proposed in the new application. But the modification application was also submitted in February, as I mentioned, and when we went on the record for one of the initial meetings of the request for continuance, we had expressly discussed whether or not we would extend the existing deadlines for the modification in conjunction with the extension of the vesting deadlines of the existing approvals. That was something that I requested and authorized on the record. We submitted a writing to staff in conjunction with that request. So this is a formal request to extend those deadlines, but we, again, are requesting that because of the time period that has since elapsed since we submitted the modification request. We thought it would be done in a shorter period of time. It wasn't because of scheduling conflicts and other things out of our control and staff's control. We had coordinated with staff to hold a special meeting, so a number of the extensions and the reason for the delay were agreed upon by both parties. So I think there's good cause there to extend the existing master plan deadlines in order to afford the board an opportunity to hear the improvements to the design and modifications that are being proposed.
So, Madam Chair, I think just to approach it with clarity and with your thinking on this, they are two distinct questions. The first question is there good cause for the extension? I would say that that's a question before you tonight. There's no prior agreement which would require you to apply that standard in any particular way. That being said, it is a very broad standard. So anything that the applicant puts before you that you think is appropriate to consider in that, you give it the weight that you think is appropriate to the good cause standard. But the first question is, right now, is there good cause to extend the application?
Yes, and I, for one, was a little bit confused because Mr. Landry kept referring to the new plan or modification rather than other specifics relative to the original plan, and I'm not sure in terms of good cause if it should go beyond that one item.
Yeah, I think really the question for good cause is more about timeliness. So it may be reasons like, here's why we didn't move forward with our plan by the expiration of the deadline. That could provide good cause. It could be reasons, they could say, and here's why this project is such a great project for the town. That could provide good cause. So it is a broad standard, but it should go to, why it is that you should extend the timeline.
Paper? Joe?
Well, that's exactly my question. So I'm open to the idea, but why do we need to extend the deadline?
So I think it's important to consider the fact that there is a request for a modification of an existing plan.
If I may, there was a prior deadline. Everybody understood the calendar. So why is it that we need to extend the calendar? That's my question.
So the expiration of the deadlines, I believe, is December or January, or December of this year. When we went into the modification request, we had prepared plans to submit to the town for that modification request. The initial request for the modification was done so on an administrative basis that we believed could have been done administratively without the need for additional hearings. And with respect to the planning director, it was in his discretion to refer to the planning board because of the significant changes, the road layouts, things of that nature, and it was within his purview to recommend it to the board. That was done. We submitted the application in February, and frankly, we thought it would be heard in a much shorter time frame. There was a notice issue initially with the orange sign that you may recall, so it was extended. There was, I believe, a quorum issue for a subsequent planning board meeting, and then there was a discussion to hold a special meeting and not have the application during a regular planning board meeting or even during a work session. So the dates had gotten bumped a few times. So the request is coming now because we thought the modification would be resolved, and the issue of requesting an extension wouldn't have been at issue. But because of those subsequent delays, which I'm not pointing any fingers, it happens and it was justified, but we're in a position now where we've got a lead time to hear the modification request, which is certainly going to take, I assume, more than one meeting. And additional commentary, we could run afoul of those existing deadlines. So we think it's important to allow the board to hear all the information and the material. But the good cause is really based on, it's intertwined with the modification request and the time to prepare that application, how long it's taken to get here.
So if I could rephrase what I'm hearing, just to make sure I'm hearing it correctly, what you're really saying is that in the amount of time that's passed, we haven't had the ability to look at the issues that we need to consider that extension.
Yeah, I think that's part of it, certainly. And there's a number of other factors. I mean, the economic factors, the amount of time since the original approvals, there's been legislative changes, changes in the comprehensive permit legislation. I mean, there's a lot of different
No, I understand.
changes. So.
I have to interrupt because I'm kind of new to the planning board, so I'm coming in the middle of this. And essentially what you're saying is that the give and take of all the discussion took time, and I understand that.
Thank you.
So you've answered my question. I'm happy with the request.
This is actually a question for staff, but to the best of your knowledge, do you know whether there's been any changes in either the underlying zoning or the town's comprehensive plan that for this specific area since the time of the settlement?
I think there's two aspects. There's time between the settlement and there's time between the original application. So I don't want to misspeak because there are two time frames associated with that. But I think the primary change may be associated is how you account for the affordable units. The original approval has a fee in lieu of versus providing them on site. And that was something that was allowed as part of the regulatory review during this original application and was also allowed in the settlement agreement.
But the zoning and pretty much the comprehensive plan hasn't specifically addressed
zoning
this.
has not changed. So, take away the affordability aspect in the creation of those lots, the underlying zoning or aspects of the comprehensive plan as it relates to this type of development has not changed.
And the affordable component, we'll get that to the next item. We'll address the affordable at that time.
Again, I think the stipulated agreement may weigh in on that factor.
So I don't believe the proposal for the affordable is going to change. It was fee in lieu of creating affordable housing in the original. I think with the change, it's still going to be a fee in lieu of creation of affordable housing. I think the difference is that fee in lieu option, which was available when the original application was filed, would not be the same option if it was considered now. But other than that, as far as the underlying zoning of this area, it's the same.
Thank you.
So, Peter, if the extension were not granted and the applicant then had to begin with a new master plan, they would be subject to our revisions in our regulations with regard to affordable housing, and there would be a requirement for affordable housing within the site, correct?
That's correct. One other thing to consider with regard to affordable housing is that it's always a fine line between inclusionary zoning required on site and bumping up that next level to the comprehensive permit. So I think the original approval kind of reached a compromise on that issue with the fee in lieu, but if it was filed again, it would be on site.
Yes, and the previously allowed fee in lieu is also based on a table that comes from Rhode Island Housing that dictates the cost per lot, which has been a discussion at our work sessions in the past because South Kingstown's costs per lot are less than some other areas, notably Central Falls, oddly enough.
Peter, the extension, do we have authority to grant what, specify that time, whether it be 3 months, 6 months, or a year?
Yeah, at this point you do. The original 2 extensions were 2 automatic year extensions. The statute at this point just says further extensions for good cause. So it doesn't specify the length, and it gives you very broad discretion on the reasons.
Thank you.
Other questions, comments from board members? Peter?
I mean, in regards to the extension, I feel like there has been some back and forth, and there have been some meetings and a special meeting, so I think that seems pretty reasonable. It sounds like they have been, pushing this down the road, both sides.
Mr. Landry, perhaps I could ask a follow-up question relative to the affordable conversation. Without getting into the details of the changes to the plan, which you have termed modifications and staff has termed major change to a plan, what are the chances that affordable units could be put within this development and not off-site?
So, I think it's important to understand the posture of the case at the time that it was approved. Mr. Squires is right. Part of that settlement agreement was the fee in lieu discussion. It was an option available at the time. It's not something we're proposing to change now. But there were also other conditions as part of that settlement agreement, the fee in lieu being one of them. The other were the setback restrictions. There's a 100-foot setback requirement as part of the settlement agreement, and I think it's 50 feet or 50-foot side yard setback.
25, I believe.
25.
And it's minimum for both of those.
That's minimum, but those are significantly more stringent than what's allowed by right under your existing zoning ordinance. So my client's not proposing to change any of those things. But if a new proposal came in, the density could be significantly higher. It could be significantly higher under a comp permit. None of that is proposing to change. We're actually reducing the density with the modification request. So I think there was a lot negotiated at the time as part of that settlement agreement. We're respecting those conditions. We're not asking for any new zoning relief. We're not asking for any of that to change. It's really purely a layout change, and the spirit of the original approval and settlement agreement will remain intact.
Thank you.
Hi, Roland Fiore, the owner of the property. The primary delay on our side was to reevaluate the house and its historic value to the community. And the market has changed dramatically where I think a B&B might be the way to go there long term. I'm not in any rush to do anything. I'm just trying to codify this legal situation. I think if we just went 3 months out to 6 months, mirror what we're doing so we can make a decision on what plan we want. And if I don't like that, I'll throw all the plans out and start over again. So I don't want to waste too much of your time here. We're not looking to 3 to 6 months, I think, is fine based on the town's delay and our delay over the past year. Thank you.
Before you leave,
Certainly.
just to be clear, so you would be open to modifications? You mentioned the potential for a B&B for the house itself. So
That's all in the plan. The plan is, that's what I said, I'm a little bit caught off guard. Either people haven't, well, we're going to make the presentation, but we're talking about preservation of the house with 5 suites and an owner living there without any construction alterations at all to the property. That's really the big issue. If you go back and look at the original plan, what I really didn't like about that, and we put that plan in very fast, and the primary reason we put that in was to establish the setbacks. We rushed the plan in. If you look at the plan that was approved, it encroaches on the setbacks that we had changed from 100 on the front to 25 on the sides. So when I really took a good look at the plan, I said, here we are, we're going to put utilities through the backyard and a road. You're really going to destroy the house by doing that. And that was the primary issue there when we decided to put the units, the road on Perry Avenue, where you have a right to do that, and it sort of makes things a lot cleaner. It allows the house to stand alone and be used for another use instead of broken up and beaten up a little bit.
thank you. Other questions from planning board members? So we have a decision before us relative to granting of the extension. I heard from Peter. I'd like to hear from the rest of the board members. Joe, go ahead.
So on these requests for extensions, I just want to make sure that we're consistent with other projects. And typically, at least my deliberation has been that if there's no change to the zoning and there's no change to the comprehensive plan, to grant the extension. And there is no changes for those. There is a change in winter housing, and that is a pretty significant change. However, it seems that the applicants are working with good faith with the town to get a plan that's better for both the town and themselves. I'm inclined to do an extension for the amount of time for us to hear the project, and perhaps another month or two if that's how long they've been working with staff. So I would say 3 to 6 months, but no more than that.
Thanks, Joe. Anyone else? Susan? What is, I'm just asking for input.
I appreciate Joe's perspective on not having an extension. I'm willing to talk about an extension, but I would also like to limit the length of that extension. And I think that 3 to 6 months should be adequate for us to flesh all this out.
People?
I'm relatively new, so I appreciate the fact. What I've heard is there's cause, and I'm thinking about good cause. And I appreciate Joe's input. And I mean, as long as both sides have been responsible for the need for the extension, I think that constitutes good cause. My hesitancy is I'm not hearing from the planning board. I heard Joe's perspective, and I appreciate that. So I certainly think there's cause, and I'm amenable to voting in that direction, but I just want to make sure that the board is consistent with that.
Could I just ask one more time that doing this extension in no way ties us to any changes to this plan? It's entirely a separate thing.
It is entirely separate. This is just the time frame within which you need to make a decision. It's also important to keep in mind if they were to move forward with the plan or a change plan, that's also the time frame that they'd have to have their preliminary plan filed in order to keep the vesting in place. So it may take a couple of months to decide the modification, and then the applicant would have to hurry up, get the preliminary plan together, and get that filed in order to stay vested.
Thank you. So if their rationale for needing the extension was because they were proposing another plan, that other plan isn't relevant to the extension. It just happens to be the reason, but it's not. Sorry, I just keep beating this, and I want to make sure.
Right. It does not commit you to vote one way or the other on the proposed changes that they're going to propose to you. It just will give the applicant and you some more time to consider them.
I think that it's a reasonable request. The applicant has given us adequate information that would allow for forward movement in the future, given a reasonable time frame. So if somebody would like to make the motion, I'll make that motion. Motion from Caper and question for legal counsel. Is there any specific criteria that needs to be part of the motion for an extension of time frame for this?
All you need to do, since it's not an automatic 1 year, is state the time frame. Make clear that it's measured from the expiration period and not from the night of the vote.
So that would be from December of 2024 going out to, I believe Mr. Landry had said, up to 6 months.
Right. And then you just say that you find good cause and give a very brief explanation for why you believe there is good cause, and that's enough.
Caper, does your motion concur with those items?
Yes. I think that good cause has been shown that we should extend the time frame until, what did you say, June 30th of 2025. And if anyone disagrees, I invite them to say so before they second the motion.
Oh, they will. We have a motion from Caper. Do we have a second? Second from Joe. Any further discussion?
So let me just clarify, right now it's December 1st, so this would be adding 7 months?
Right. So I think the extension now is just to the date certain of June 30th, 2025. So if I was better at math, I could tell you exactly how long that is. But
Yes, you're correct. It's 7 months.
If it's
You're smiling, so I don't know if that means you're...
No, because I'm
Okay
trying to
with
do the math in my own head. So,
Right.
6 months was, you heard my client, he was agreeable to that. The settlement agreement, which I believe would be the term of the approval, and council can correct me, was January 23rd of 2020. So if that helps in terms of calculating, I think the June 30th timeline would kind of fall within the appropriate 6 months.
I think, Madam Chair, for the motion tonight, you don't have to worry about 365 days because you're less than that right now. So 6 months with a date certain of the June 30th, 2025, I think is perfectly appropriate. If Mr. Landry came back and said, I'd like another 6-month extension, then we really need to count days.
Any other comments? Hearing none, all those in favor say aye. Aye. Motion carries. Moving on to our next agenda item, this is, as referenced earlier, the public hearing, major land development change to previously approved conceptual master plan 571 Main Street. Mr. Landry, you have the floor.
Thank you, Madam Chair, members of the board, Attorney Matthew Landry on behalf of the applicant Roland Fiore as it concerns 571 Main Street. I appreciate the vote and the courtesy on agenda item 1. I think it'll allow the board sufficient time to review what we're about to present to you, and hopefully you view that as an improvement to the existing approval as we do. There have been a number of significant changes to the plan that we deem improvements, and I'd like to just summarize some of those for you. But by way of background, I do have copies of the settlement agreement that I think may be helpful to the board to have. With your permission, Madam Chair, I'd like to just pass those out for your...
Certainly, I believe we have them, but go ahead.
And again, just for the record, Madam Chair, that's the January 23rd, 2020 settlement agreement that was subject to litigation and appeal on the original master plan approval for the 571 Main Street application that came before the board sometime in 2014, 2015. The reason I think it's important to understand the background, again, as just previously discussed, there was a lot of back and forth between the applicant and the town, and a number of considerations that were made as a result of that settlement agreement. But I want to be clear, there are actually two separate issues in that case. One, the zoning that was in place or that was applicable to the application at the time was at issue. There was I believe a 44-unit project, apartment building off of Perry Ave there to the rear of the property called Beaches, and there was a question about the zoning that applied with that project. We don't need to get into the details of what that entailed, but there was a question about whether or not the zoning that was applicable to that project applied to the new application, or whether the changes in the zoning at the time, the setbacks applied. And the result of that discussion and that appeal and the litigation resulted in an agreement by the town and my client to have an increased setback distance, as I've already mentioned. So it's a 100-foot setback from the front yard and a 25-foot setback from the side yard, which is significantly more stringent than what would be allowed by right for a land development project on the property. That condition remains intact. The fee in lieu, as we've discussed, that was an option at the time of the initial approval. We're not proposing to modify that or change that. Really the spirit of the settlement agreement and that approval remains intact with the new modification request. The second element for that settlement agreement, there was a separate action by my client against the town as it concerned some stormwater runoff onto the property from the northwest quadrant of the property onto his property across Perry Avenue. That was resolved as part of the settlement agreement too, and is obviously something we're very much aware of and will be improved over the course of this permitting project. So with that being said, the application for modification is a modification of the approved plan before you, but with some significant improvements. And I'm joined by Molly Titus from Dupree Engineering, who prepared the site plans. I'll ask her to compare the approved plans from the 2020 settlement agreement versus what's being proposed now. Paul Bannon from Crossman Engineering is here with respect to any traffic questions you may have, and Chris Mazier from 401 Architecture, who's the new project architect with respect to the modified application. So just to highlight some of the differences, the original unit count was 36 units. 36 units is staying the same. We're not increasing them, we're not decreasing them. That remains the same from the existing approval. However, one change to the unit count and the density, there were 10 three-bedroom units proposed as part of the original approval. Those have been eliminated. They're now all two-bedroom units. So there is somewhat of a significant reduction in density by removing those three-bedroom units. There'll be 32 units separated in the different quadrants of the property, with 4 units in the house itself. And as you heard my client testify on the other agenda item, really the spirit behind this modification request was to respect the integrity of the existing home. The existing approval includes utilities and a road that actually runs behind the main home and the property, kind of where the pool house is and where the existing driveway is. That would disrupt significant features on site, potentially, and create, I don't want to say an eyesore, but certainly interfere with the integrity of the existing property. So the modification request actually eliminates that road that goes behind the property and actually, in effect, separates the development into 2 kind of separate quadrants, the northwest rear along Perry Avenue, and then the lower right quadrant of the property, which is the southeast, and then keeping the main home intact with 4 units. So by splitting up the utilities and eliminating that roadway, it again respects the integrity of the home, the existing features, and keeps those amenities intact. And so To that end, one of the proposals that we'd like to incorporate as part of this amendment request is this idea of creating a bed and breakfast out of the existing home. It's an option that allows for some flexibility, but also ensures that the main home will remain intact. The amenities would go with those, with that bed and breakfast use. A bed and breakfast use is allowed by right in this zone. It is subject to development plan review, so that may require a separate analysis at some time. But we think not splitting the property, but redesigning the property in a way that respects the main home, the pool, and the accessory structures that go with it would allow a bed and breakfast use to come before you. And it would also give my client the option to remain in the home in an owner's suite, continue to live there, maintain it, and have that bed and breakfast operation. There's also a 10-year phasing plan being proposed in conjunction with this, and that's a pretty significant element to the modification request. And the reason being is my client's not in a rush to get into the construction of this project and developing it. The 10-year process or phasing plan would allow him to develop this gradually over time, perhaps beginning with the bed and breakfast use, exploring that option with the town, and then developing the units in phases. And the proposed design before you allows it to be done in those phases because of how the utilities will come in and be separated in different parts of the property. So again, I think that's an important aspect of it. Most, I think developers would rush in to either knock the house down or jump right into development. But the 10-year phasing plan really allows us to be done over a gradual basis and done in stages, and obviously market conditions and things that may change over that time. So I think that's an important element. Again, the 100-foot setback, 25-foot setback will remain intact pursuant to that settlement agreement. We're not proposing any changes. Total impervious surface area is being reduced. The lot coverage is also being improved and reduced. Open space is being increased. The reconfiguration of the units, we eliminated the 10 three-bedroom units, so there's a reduction in density. Right now, by right, your zoning regulations allow 4.3 units per acre for 3 bedrooms and 7.71 units per acre for 2 bedrooms. And well under that density allocation, especially with the 3-bedroom unit elimination. And as you know, if this proceeded under the new comp permit regulations, if it's on sewer and water, you're subject to a 5-unit per acre density bonus. So again, we're well under what's allowed by right, and multifamily developments are allowed by right on this property. The other significant elimination is what these 6 car barns that abut the Elks Lodge property. As I recall, that was a point of some contention during the initial master plan review stage. Those car barn structures, the elimination of those structures will actually increase the setback distances further from that Elks property. And in conjunction with that removal, the proposal is to put 1-car garages below the units. So there will be a minor increase in height, but we're well within the limitations. We comply with all other zoning setbacks. We're not asking for any relief, any waivers as to height or any other setbacks. So none of that has changed, and none of that is different than what was originally proposed, except for the garages. The other change to this is the road, Perry Avenue, which is a 50-foot right-of-way that runs to the rear of the property. The existing master plan approval contemplated an entrance roughly 100 to 200 feet closer to the east for access. The relocation of some of the units more to the west requires moving the road further down Perry Avenue. Now it's contemplated at my client's expense to bring all the utilities into Perry Avenue, which I think would be a significant benefit to the residents. There's no sewer, there's no water along that street. They're all on wells and private septic. So bringing those utilities in along Perry Avenue would be a significant improvement. The road would certainly need to be widened. And again, Molly can speak to that in a little bit more technical detail, but the idea is to widen it, make it safe for emergency access. We did receive a letter from the fire marshal with no objection as to these plans. Again, it's conceptual, so we'll have to work hand in hand with the town engineering and staff on, during the preliminary plan phase. But The idea is to widen that road, bring the utilities in and provide access. And then all the applicable setbacks, wetland setbacks, all of those things will be addressed, no increase in runoff as would be expected. And then with respect to that water issue and the runoff onto the property in the rear, anything that we do on the site is going to be an improvement, but we'll continue to work with the town and need to work with the key players to address any issues of runoff from that area onto the property to avoid any further issues, and I think that'll be an ongoing discussion with the town. So that's enough of my outline and discussion. I think I'll ask Molly Titus from Dupree to come up and discuss the differences between the plan, what's being proposed, and go through the site plans that she prepared.
Thank you. Before that, I just have a couple of general questions. One is, you referenced the northwest quadrant, and you said that it had been resolved. Was it resolved in a design sense? I remember reading in the agreement, stormwater trespass, which is certainly a new term. So perhaps you could...
Sure. So there was a separate litigation matter as part of that settlement agreement that there was a lawsuit against the town for causing runoff onto the property from off-site conditions, town conditions in that area. It was resolved in the sense that the lawsuit was dropped in the spirit of moving forward with the plan that was proposed, understanding that improvements would be made certainly on-site, but working in conjunction with the town to improve off-site conditions.
The other general question is, how can this board ensure that the affordable off-site units are built?
Well, it's a condition of the settlement agreement that fee in lieu is subject to it. We're not asking for that to change, but it is part of the settlement agreement.
This is ultimately their responsibility would be to pay the fee in order to get their certificate of occupancies for their units. Once we have the money, our responsibility would be to obligate those funds to create affordable housing, either through the town or what may be more likely through a third-party entity that is specializes in creating affordable housing.
So it's not up to the applicant to actually build those units off-site?
They're just paying the money.
Just to be clear, everyone.
And just to be clear, Pete, there is a time limit on which we have to expend those funds, correct?
That's right. There's a 2-year time limit. So when the funds come in, that's going to start a clock for the town to figure out who this money should be allocated to probably a nonprofit. That might be the easiest way to do it, rather than have the town bid it out as a public works project. So that's just something to keep in mind as we go forward.
I believe one of the downsides of the fee in lieu was exactly that if you don't use the money within 2 years, it goes to Rhode Island Housing, which seems somewhat unfair. Nevertheless. Caper?
But having said that, and I agree with you completely, but that's the agreement that the town entered into.
Susan?
Maria just asked you to explain the northwest quadrant. Could you clarify that further, that you said that there would be on-site improvements for that stormwater and off-site by the town? Is there something, is there some sort of agreement with the town or some sort of arrangement where there's expectation or a plan for any improvements on the town-owned portion of that property?
No, so the lawsuit by my client against the town was to resolve the runoff issues onto his property. That lawsuit was dropped as part of the settlement agreement, but there was no formal agreement to resolve those issues or how it was going to get resolved. I can tell you that the on-site improvements, to whatever extent this development gets built out, we can't increase runoff off of our property. That's our obligation. So we're obviously going to comply with that. But I certainly, as part of the Perry Avenue improvements that will be required and the extension of Perry Avenue to create the access point onto our property will require significant infrastructure work, sewer and utilities, but certainly runoff. And it's our intent to, and we have to, work with the town in order to resolve any issues along Perry Avenue to the extent they come from somewhere else. it's a discussion and a dialogue we'll have to have with staff, but there's no formal requirement that the town has to do anything at this point. But I think in the process of fixing Perry Avenue and widening it and bringing utilities in, that's certainly going to be part of the discussion will need to be addressed at that time.
So if this plan were to go through and you and your client are extending Perry Avenue, whose responsibility is it to control that stormwater that you're talking about from that quadrant? Is that now tie the town in to an infrastructure project that will support your road, or are you collectively proposing that all of this issue will be resolved by you?
So that's a good question. So it's a 50-foot town right-of-way. So the town owns the road and is responsible for the maintenance, but this proposal contemplates an extension of bringing the utilities in. That'll be at my client's cost. But it will require approvals from the town to do that because it's work within the town right-of-way. So we'll have to work with the town on the plans and the infrastructure changes, and to the extent that runoff and drainage is part of that, we would be required to work with the town and submit those plans. But the final product, it is a town road. We don't own that road, but we're proposing to extend it and improve it and pay for those changes. But that would certainly require collaboration with the town. I think it's really a preliminary plan level issue, but as we go through, that's going to be heavily vetted and part of that process. So to the extent the town is responsible, I believe they are because it's a town road, but the town will have say and purview over how those infrastructure changes happen because they're part of our request to change the road. If that makes sense.
It does, and thank you.
Madam Chair, I'm sorry. Just to touch on that briefly, with regard to the proposal to have the improvement to the town right-of-way, there's two aspects to that. One is that the town would have to accept that to the council. So this plan as proposed, I think any iteration that involves that improvement to a town right-of-way would need to be conditioned upon the town agreeing to accept that extension of their right-of-way. As far as the cost of the initial infrastructure improvements, that can be put on the applicant to build it up to town standards and to town's approval. But then after that, assuming the council approves accepting that extension of the right-of-way, then it would fall on the town to maintain it.
Madam Chair, just to take that one point further, and I think Mr. Landry can potentially correct this estate. When you were discussing the lawsuit, I think you used a terminology with regards to off-site, that the town will be required to do the improvements off-site, and maybe you needed to say that the town would need to approve your client's proposal to improve Perry Avenue right away, that the town has no responsibility to physically make the improvements themselves.
That's correct. So as part of this, we're requesting those improvements along Perry Avenue, which would include obviously off-site improvements. So we would need to work and get the town's approval to make those changes. That's great.
Just to add one other thing to the stormwater conversation, you have significant experience in your field. The applicant is very experienced in his field as well. And I think we all understand how difficult it is to manage stormwater, particularly relative to climate change. And as you move forward with this, and it is a significant undertaking financially and in terms of the engineering, it will be important to understand the existing conditions, the watershed, the fact that you're at the base of a hill, soil conditions, and so on. So I think keeping those things in mind as you move forward in cooperation with the town would really be of great benefit with that understanding early on.
Yeah, of course, and we have every intent of working with the town collaboratively to address those things. We think it's important. It's important to the residents along Perry Avenue. So it will be a collaborative effort, but I think it would result in a much improved design, bringing utilities and things of that nature. And the Perry Avenue access was contemplated in the original approval. We're extending it further down, further westward. But the existing approval did contemplate access off of Perry Avenue, so it's not a stretch or a major change to what was originally discussed and contemplated, but we are extending it further west to relocate it, but I think that's important to point out.
Anything else before we hear from engineer?
Mr. Landry, can you or your client maybe expand a little on your vision for the bed and breakfast? And I realize that would have to go through a separate development review. I'm trying to understand the big picture of the site and how it all relates, how much potential traffic would be as a result of the bed and breakfast, how many bedrooms you'd have. So kind of give us the max scenario that you thought about for that structure.
Sure, and I can let my client speak to this because he's passionate about it, but it's a 5-room, 5 suites, an executive owner's suite, so he can remain in the residence and be there. So I think that's an important element, is he will continue to live on the property, particularly through the 10-year phasing plan that would be proposed. But it would be a 4-bedroom bed and breakfast, so it's not a hotel, which is actually permitted in this zone. It's a much more reduced impact, I think. The parking and the infrastructure will be there in conjunction with the rest of the development, so there will be ample parking, I think, already on site, but that would all be part of the process. But keeping the property as a bed and breakfast or maintaining it as a bed and breakfast would allow my client to share it with the community, make it a community function area and opening it up to the public and allowing the public to enjoy the historic nature of it, but also maintaining the integrity and the spirit of the home and not making substantial changes to it. And the bed and breakfast element was a really important consideration too for the design change, but not running the utilities and the road behind the property. It would have impacted the existing pool and other structures there and disrupt the integrity of the natural features on site. Those would remain intact with this change, so there would be minimal impacts to the existing structure, and we think it's an appropriate use for the home. Yeah, and I'll have my client just speak to that.
Thank you, Roland Fiore. The key component of this, I think, is the entrance being changed to Belmont, and I think that traffic engineer can discuss that. So that would be for the bed and breakfast as well as the condominiums. And the access on Main Street would be left intact for just the emergency vehicles. But I envision a very nice entrance there, wrought iron gates, etc., to take advantage of the grounds there. And we're talking about the property comfortably. The house has 5 suites, and then the owner of the house would have to go in the servants' quarters. And those are currently in place, the original servants' quarters. And all amenities on the site, as mentioned, would go with this property. The property's approached quite a bit by people trying to have movies there and so forth and so on. So this might allow some of those people to come forward and do it the right way. But we do get a lot of calls. I get a lot of calls that people want to stay for the weekend. If they already think it's a bed and breakfast, they'll drive right up and find out. So that's the idea there.
You said 5 suites.
Yes.
Those are 1-bedroom suites.
Yes.
All right, so when we go forward and we evaluate these changes and we evaluate the site, we can do so with the understanding that the main house will have no more than 5 1-bedroom suites.
That's correct. And then, like I said, the owner's quarters would be the right side of the house. So that would be a couple of bedrooms over there.
So it would be a total of 6 suites, 5 of which would be
correct.
No more than 5 would be 1-bedrooms, and then
That's correct. And that's what the zoning calls for, the owner to live on site.
Thank you.
You're welcome.
So before you sit down, Mr. Fiore, the project that we're looking at is a 36-unit development. But now you're removing the units within the house. So are we now evaluating a 32-unit project, or are you planning to compensate for units somewhere else? Like, are you Is this reducing the number of units that we are talking about?
If the bed and breakfast project works out, then those units would not be built in the main house, that's correct. We're just reserving the right because 36 is allowed on the site.
So, I can comment. So the existing master plan approval is for 36 units, inclusive of 4 in the home. We're not proposing to change that, but we are proposing that if those 4 units in the home are not built, they could be utilized as a bed and breakfast. But I am cognizant of the fact we would have to come back through a development plan process and request that change. So my client is trying to keep the door open for that bed and breakfast use possibility, knowing we would be subject to further review. But at this time, the plan in front of you is to construct 32 units on site and 4 additional units in the existing structure, keeping the structure intact but not being used as a bed and breakfast.
Okay, and I know this is picky, but I thought it was 4 one-bedroom suites, 4 units. But then you just told Mr. Murphy that it's 5 one-bedroom units plus an owner.
That's 5.
So out of the 36 now, you've got 5 in the house, and so we're down to...
No,
Madam Chair,
they have nothing to do with that condominium count. These are just
Madam Chair, if I may, I think Mr. Landry, in my view, clarified the question. You have an application before you for 36 units. There is no application before you for a B&B. At some point in the future, the landowner could come back with an application to, in essence, abandon his approvals to build 4 units within the main home and instead seek a permit to operate a B&B. I think they're trying to be forthright in disclosure that could happen, but that is not jurisdictional subject matter in this application. You're actually looking at a 36 unit, 18 north, 4 in the main house, and 14 on the south side. So, Mr. Landry, if I misspoke, please clarify that.
Thank you, Mr. And that's exactly right. And, the discussion about the bed and breakfast is, again, my client, the 10-year phasing plan. This is all part of a long-term vision for the property, for the home, and he's been a long-term caretaker of that home for many, many years. The bed and breakfast option, we wanted to disclose to you as, his thoughts and the potential for the property, which I think is a very good intent. However, the existing approval is already contemplates 4 condo units in the existing building. The building will remain. The amenities will go with it under this proposal. But the 36 unit count and the units in the home haven't changed from the original approval. The bed and breakfast discussion, bed and breakfasts are actually now allowed in the zone. I'm not sure they were back in 2014, but that is an option that my client would like to explore, and the 10-year phasing plan would allow him to consider that as the project develops and moves forward.
Thank you for clarifying that, but I think I just wanted to verify for myself that if he's vested for 36 units and you choose not to construct them in the main house, that those extra units aren't now, you're still vested for 36 units, and now there's another fourplex going in to balance and continue 36 units since you're not doing the main house.
Yeah,
and I guess I just wanted to be clear that whether you do the house or not, that would count towards your 36 units, and there won't be another fourplex going in.
Yeah, I respect it's a very valid point. So the plans in front of you contemplate 32 units in the 2 quadrants of the property and 4 units in the main house. If we wanted to eliminate those units for any reason and reconstruct them elsewhere on the property, I imagine that would constitute a major change, and we'd be back in front of you asking for a relocation of those units. We could potentially eliminate those units and then only come back for a request to turn the house into a bed and breakfast. So the plan in front of you is what is being approved. We can't deviate from that to relocate those units elsewhere without further approvals from this board.
Thank you. We do appreciate you sharing your thoughts for potential changes in the future.
Thank you, Madam Chair. If there's no further questions at this time, I'll introduce Molly Titus from Dupree Engineering. I think she'll be able to educate the board on and then some of the changes in the more technical aspects of the project.
I have one question. I can't find in the settlement agreement where it refers to the affordable housing provisions.
There's a page, I have it in front of me. There's a page towards the end that lists the conditions. It just says fee and lieu. On page 3, under the paragraph now therefore, there's numbered paragraphs, and it's the agreement of the parties. In the middle of that paragraph, after it talks about setbacks, it discusses a provision for a fee in lieu of the required low and moderate income units.
So as you've had an opportunity to review the settlement agreement and think of how you might want to modify it, similarly, it strikes me that the town might want to modify it as well. As I understand it, this is providing, I still can't find the provision, but as it was described earlier, you're talking about providing funds for affordable housing, but is there a way to consider modifying the plan to include affordable housing on site? So that it's actually guaranteed?
I asked that question earlier, yes.
As we're basically, we're now talking about
Mike, Kate, Mike.
Oh, I'm sorry. But as we make these changes, I think it's also important that we think about how we provide for affordable housing in our community, rather than simply providing funds for that, which can expire if they're not utilized in a specific point of time.
Great. So I just want to be clear, and thank you. I appreciate that position. We are not requesting a modification of the settlement agreement. I think that's an important point. The conditions remain intact. The only modification to the plan that's before you is the configuration of the units, the Perry Avenue infrastructure changes, but none of the other conditions of the settlement agreement are being proposed to be modified and are in front of the board.
I appreciate your drafting point, but I think the spirit of my proposal remains the same. Thanks.
Please continue.
Thank you. So, Ms. Davis,
Good evening, Chairman, members of the board. Molly Titus, Dupree Engineering. What's on the screen today in the top left corner is the existing approved master plan for 36 units. Upon listening to your discussions this evening and changes that may have taken place in legislation and regulations over time, while there were no changes to the town ordinances or zoning, there were changes to the wetland regulations. So the existing driveway on this property is located to the right of that isolated wetland in the top right-hand corner. And since the approval of this master plan, that isolated wetland now has a 25-foot setback. That wasn't a regulation at the time of this approval. So taking that into consideration, you can go to the new plan, please. We have come up with this new site plan. So under this version, as Attorney Landry expressed, we have moved the access point about 200 feet west, and this affords us the opportunity to maintain all the regulatory setbacks to that wetland. As part of this extension, we would be providing new utilities within Perry Avenue. The existing pavement in Perry is about 16 feet wide. Town standard for this type of road would be 24 feet of pavement. We would be looking to widen land south. So on the south side, our side of the roadway, about to 22 to 24 feet. There are existing utility poles, driveways, residents to consider, but an additional roadway width would certainly provide increased safety for those folks for emergency access. We evaluated the utilities in Belmont Avenue, for capacity for this development. So we've surveyed the sewer line, we calculated slopes and inverts, and this new sewer line for this development would be all gravity. So the residents of Perry Avenue would have the benefit of the ability to tie into this new sewer line constructed by my client and have the ability to abandon their on-site wastewater system treatments and then also tie to a public water supply. The fire department has reviewed this. We would be subject to a 1,000-gallon per day fire flow requirement. We've provided on-site turning movements that have been approved. So Dennis Bernier, the fire marshal, has reviewed and approved this plan for both fire flow and access to all portions of the site. We had this plan reviewed by Veolia Water. They modeled the entire water system in Belmont and surrounding areas and confirmed that an 8-inch main on our site for both locations would provide adequate service and be well within their limits of their model for serviceability on Belmont Avenue. After that, we went through and did stormwater calculations. So at this time, we're proposing on our site, just to mitigate the proposed improvements, infiltration for roof water and then pervious pavement for driveways. These areas on the site have been looked at for soil capacity and volume for infiltration. It is noted, obviously, that we are sitting on a slope on the side of a hill, and I would like to say DePreet's reputation of designing safe systems is intact, and we will certainly comply with all the state regulations and town regulations and be cognizant that the standards in place have been constantly changing. And, we understand that increased rainfall is a reality, and we've been doing above and beyond with a lot of our designs as of late. For the remainder of the changes, the other item of note is the reduced number of buildings. We've removed the 6 car barns. All of these homes will have 2 car garages beneath the units, and then the 12 parking spaces to the east of the main house will be part of the parking area for those units within the existing home. That is the site plan. We've got reduced impervious, we've got increased open space, we have 10 fewer bedrooms, and an improvement to utilities and road construction for Perry Avenue. Thank you.
Thank you. Questions relative to engineering from board members? Susan?
Had you considered bringing utilities in from Perry Avenue without having a driveway from Perry Avenue? If you were concerned about the utilities not passing behind the house, you could theoretically bring in the utilities from north of the site as opposed to in from Belmont Avenue.
So remain the driveway through the rear of the existing home, but
if you left the original plan intact, but didn't want your utilities running behind the house, you could theoretically bring them in from the northern part of the site?
You could, also the intent was to remove the driveway. That rear portion is in a courtyard and gardens at this time, the rear of the home.
Okay. Thank you.
I had one question. I'm sure this has been considered, but I want to emphasize the fact that the relocation of the road off of Perry Ave 200 feet west, your road is going to bisect essentially 2 wetlands, and I think it's important that you assess this early on and think about any kind of unforeseen potential impacts.
Yeah, we will be taking a considerable look at water pathways in the future and how to mitigate them and control the transversing of water from the upper to lower wetland.
Other comments with regard to engineering? Susan?
I just wanted to add this one still. Good evening, Madam Chair, members of the board. Chris Major, Fallen Architecture, now involved in the
design and conceptual plan of this project. I think in response to that, the intent as we move forward is to respect the historic nature of is the William Davis mansion, and it was designed by Albert Harkness, and one of the structures, it's historic in nature as well, would be totally impacted by that continuation of road, and it's called the Monk's Walk, and it was designed as a tertiary structure during the design of this home. So I just wanted to add that because that structure too is historic in nature.
National Register, correct?
Well, the home is on the register, but it was nice about it was designed by that architect, Albert Harkness. So it's complementary and kind of part of that property. He designed the courtyard in the back, which is beautiful. So impacting that, I think, the new intent is to not impact that. And as we design and move forward, the intent is to really respect that historic nature and design that he provided for the William Davis mansion.
Thank you. If there are no other engineering questions at this time, please continue.
Ms. Davis, if I could just ask you, is it correct that there's no zoning relief being requested in connection with this application?
That is correct. This new site plan does adhere to the stipulated side yard and front and rear setbacks as part of a settlement agreement, which the current approved plan, the accessory car barn structures don't hold those setbacks. So.
Ms. Titus, are all the applicable wetland setbacks and other state regulations being adhered to?
Yes, this plan has just been designed to comply with the new wetland regulations that were enacted after the original approval.
Those wetland regulations or setbacks strike that there were no applicable wetland setbacks at the time of the initial submission? Is that correct?
That is correct. These wetlands did not have associated buffers, and now they both have 25-foot buffers that we will respect.
And your professional opinion, is that an improvement from the original plan?
Yes, staying farther from wetlands is always better.
Ms. Titus, in your professional opinion, is there anything about the modified plan or modified proposal that would change any of the original findings of the original master plan?
I don't believe so. We have, the continuation of access points from both Belmont and Perry Avenue. From an engineering perspective, we have less lot coverage. We have, in turn, less stormwater runoff. There's no waivers or modifications requested from that plan.
No further questions?
Thank you.
Thank you.
At this time, I'm going to ask Chris from 401 Architecture just to provide a summary and a background of what the conceptual or proposed idea is for the architecture for the property and some of the background on the house. Just state your name again.
Sure. Again, Chris Mazur, principal at 401 Architecture in East Grim. He's also a resident of Wakefield. So the project, as I mentioned, the historic nature of it was designed by an architect, Albert Harkness, who's a very prestigious architect from Providence. And it was designed for the Miller family in 1935. The intent as we move forward, and we're purposeful in not providing design as of yet because we want to get feedback from the community, the board, etc. But the conceptual plan, and we've talked about it, is to respect the established aesthetic of that home, of that site, and really develop these units, which are now smaller in nature and footprint, with that established aesthetic in mind. So it's quite simple if we put it in that way.
Susan, do you have a question? Joe?
So I certainly appreciate that. I mean, it's just a beautiful piece of property, and it's, the gateway to Wakefield. I know you don't want to hear that after all the what we went through with the property on the neighbor, but it is such a beautiful property. And I'm concerned with the layout that you show us on the site plan, because what it looks like right now is we get this beautiful property with this beautiful mansion, and we're sticking townhouses in a row right on the side, as many as we can fit. And I certainly can appreciate the property owner's rights, and at the end of the day, the density is less than what you probably could get. but I think the architectural standards really start with the site layout and what you see from the street and how those are grouped as maybe as kind of a little community and how those buildings match up with the existing one, the vegetation on the site.
Yes.
And I don't think, and I'm looking forward to your designs, but I don't think that you're starting off very well with the way that this site plan is, because that does not look like this nice park-like setting, which I think this could be with the same number of units. It would be a very, very difficult maybe to design that, but I think you could get there where you get this park-like setting of structures that look like older structures, but you end up with 32 units versus what's here. So I think you have a real challenge when you start off with a site plan like this to convince us that that's going to fit in with the existing property and building.
Well, in response to that, I appreciate that take. Really, I drive Belmont every day. I'm one of those, don't tell anybody, get cut across from town real quick and go up to Belmont. But that view, if you know that view, it's subjugated to really, it's above your eye level. I mean, it's a fantastic stone wall, which is paralleling Roland's driveway right now. I think the intent to put those units in that is to not take away from the view corridor that you had established coming into Wakefield. We talk about this gateway to Wakefield. And also, there's this fantastic tree. I don't know if you're familiar with the tree. I don't know the species, but it's marvelous, and the root structure and so forth. We don't want to impact that as well. So you're kind of subjugated or limited to where the density or those units can be established. Now, we've made every effort. With that said, in the massing of them, can we break up maybe the intent is the duplex as opposed to the fourplex was to provide a little view corridor to the existing mansion. But Joe,
I look forward to it. I think the vision here, since we're going to end up approving a good number of units. He has property rights. He has densities that are laid out in the zoning. So we're going to end up with a lot of units. I recognize I have to accept that. But I think that, at least in my mind, there could be a vision of a whole park-like setting where you're using the whole park.
Right.
And you're using structures that maybe go along with that manor house. And you're using vegetation that's spread throughout that. I mean, this looks like you're going to stick a row of arborvitae behind the townhouses and call that the division. So
I think in response to that, this is very preliminary in nature, and this is an engineering plan showing you massing and the limitations of a footprint of a structure. That design has not taken place and will take place as we move forward with that. And it's good to hear, because what is nice about this process is we haven't done that yet, but to hear feedback from yourself, the community, about what they anticipate or what they could see as a vision for that property helps us and informs us as we move forward with the design. So I don't want to say that, this is a very preliminary nature, and it's showing you there's a unit here, a unit there, but it's not showing you the intricacies or the actual development of a thoughtful or expressive design. And the intent, again, we did research on the home, and we have the existing drawings, and it's wonderful. They're from 1935, they're hand-drawn and all that. And what's great about it is the architect worked with the landscape architect. The whole property was designed, and as I was mentioning, this Monk's Walk, it's integral to the kind of beauty and expressiveness of that site and home. But again, we have every intent to establish or do something very thoughtful and nice in nature for that site. Yes.
I'm sorry, I guess, could you clarify for me that you're planning to bring us a plan that's thoughtful and integrated with the site, but that this plan isn't another plan that with some more? Does that mean?
No, it's an engineering plan, so those details are missing, are not shown in this.
What we had, what we're looking at from 10 years ago,
yes,
is very different.
Yes.
And I don't know, Jay, if you can lift that up a little bit so that we could actually see the bottom of that plan And if you're concerned, and I've heard this phrase used a couple of times tonight, talking about the integrity of the site and why the site needs to, be respected. The view from Main Street right now is a little winding driveway and a little stone wall. We got some rhododendrons. The view from Main Street here looks like two driveways and a big hammerhead, and then a street and garages and driveways. And if you compare that to the plan that you showed us from, not you, but this project was from 10 years ago, where the front of the house retained that integrity, and it appeared that there were cottages sort of tucked over to the right.
Can you pull up the previous plan?
This view from Main Street, I think, is a whole lot of pavement, cars, like that if we are concerned about the integrity of the beauty of the front of the house and of the grounds and of our view on Main Street, I think let's look at the original and how that was designed. From Main Street in this project,
So,
show me where, if I'm standing on Main Street, where am I going to see cars on this lot? My view from Main Street, where am I going to see cars and roads?
you're going to see the back of a person's condo, fourplex.
Well, we're going to hope it's a pretty back since it is facing our Main Street.
Right.
But that's my next question about your new design also. So, yes, I don't want to look at the back of an ugly building, but I assume you guys are going to build some really beautiful buildings there where I will not look at an ugly old backside of a condo.
Right.
So these are two-story,
So,
and the ones that you're proposing are three-story.
3 stories
with a garage on the first
Yes,
floor.
yes.
So is there outdoor living space? Are there decks raised up 12 feet off the ground? Like, what's your actual intent if you're putting a garage?
Hasn't
If you
been-
leave
it
the
hasn't been
garage.
determined yet, so that's, we have to develop the design and the elevation and footprint for our client.
So the view from Belmont Avenue on this new plan,
Yes.
all right, now we're looking at the old plan again. As Joe was talking about, the view from Belmont Avenue on the new plan is the backside of 8 condos in a row. And I'm finding a hard time appreciating this as an improvement over, as Joe so eloquently put it, the little cottage park-like community that you appeared to have in your first plan. Not you collectively.
Right.
As well as the cars sort of tucked back in the back in garages as opposed to along that main road, which is our view from Main Street.
Well, and just to note, I think, the effort was for this preliminary plan was to lessen the density. And, we have done that relative to what was presented prior, so.
You've removed half a dozen bedrooms, is that the reduction
I
to the
believe so,
density?
but I'm looking here, I'm just counting this 4, 7, 11, 13, 14, 15, 16, 17 units out front, and then the car barns in the back at the first plan. But no, and as we develop further, that's something to absolutely consider. With Roland, and as we progress, we'll take that feedback into absolute consideration if need be. So.
If I can just, one additional comment, in terms of the architectural design, the entire site layout is important from an architectural standpoint, correct? Yes. And part of the reason for the modification was to remove infrastructure and roadways to maintain the integrity of the house, is that correct? Yes. Okay, and this design works in turn with respecting the integrity of the existing house?
It does. The home is not touched, yes.
And an alternative proposal could include actually demolishing the existing home, correct?
I believe so.
Just to add to what Susan and Joe have said, Mr. Mazier, this is an excellent opportunity to solicit feedback from the board and from the folks in the community.
I believe that's
and
right.
As you well know, all the great architecture in the world cannot necessarily mitigate poor lot placement or poor overall design.
Right.
So as this is relatively early in the stage
Yes.
for this new project, it gives everyone an opportunity to improve as we go along.
Absolutely.
And I'd like to say one more thing and then I'll stop. I appreciate your efforts to maintain the integrity of the house structure, but I'll hope that doesn't come at the expense of the integrity of the rest of us who live in this town and appreciate the beauty of that property. I appreciate not wanting to lose the pool, but we all will see the alternative,
Yes.
which appears to be a big paved hammerhead right up on Main Street with cars and garages and driveways and the buildings going up an entire story, another
Right.
whole level. These are 3-story buildings, which is that actually the same height as now as the house?
It's, well, the height restriction is 35 feet, so.
I know.
No, but I don't know, I'd have to look at the drawings of the existing home, it's above 35 feet.
Like 35 feet is a pretty high house,
It is.
especially if from the view from Belmont Avenue with a whole lot of second floor decks and backsides of
Well,
condos.
consider if it's 3 stories, you have you call it, a 9-foot first floor, 9-foot second floor, and, or 10 feet, so you're still pretty tight within that 35 feet. But the intent, you look at the roof, the kind of French provincial roof that's designed of this home, it's well over that height. But I respect your position on the entry, and I'm just thinking, because I drive by it every day, I'm just trying to think in my mind, visualize what I'm seeing, and I see it's that vegetation and kind of barrier we're not going to lose. So I'm just trying to visualize as I drive on Main Street or Belmont what you actually see, and it's really it's buffered too. But I respect that, and I think as we move forward, we'll certainly take that into consideration in terms of the architecture and the layout of these units.
Thank you. And the last thing is that the way this is planned right now, you have that pavement extending right up to the property line, or maybe the stone wall. So it looks like at this
The
point,
hammerhead, the turnaround?
yes,
Yeah.
if you do intend to keep that screening rhododendron, those big, beautiful rhododendrons, this plan does not balance with that
Sure.
choice. This is clear cut right up to the stone wall or up to the property line, according to this plan that you have here.
Yes.
And we know you're not the landscape architect,
I
but
know.
it's good to get this feedback
no,
early on.
absolutely. Well, again, I think, as I mentioned, it's nice to hear this. It really informs the design as we move forward.
Yes,
Because it's infantile really in its presentation right now.
it's an evolution.
Right.
Any other comments with regard to general site layout / architecture from board members? Please continue.
That's it. I think, again, we just wanted to present to the board and the public that we have every intent to try and contextually respect the nature of this site. I myself live here and, again, drive by it every day. It's a beautiful mansion. I know the architecture of, Harkness and what he means to the Rhode Island itself. So it's a good project as we move forward.
Thanks.
Madam Chair, at this time, I don't have any additional testimony. I welcome any comments or questions from the board that you may have. Again, I think it's important to just highlight that the intent with this modified plan is to improve on the plan that's already been approved. We're not changing the density, we're reducing it. If anything, the unit count is staying the same. The layout configuration was done in the spirit of trying to maintain the historical nature of the property as best as we can. This is a very conceptual stage of review. It is going to involve extensive landscaping plans, buffering plans, architectural plans that will help us visualize this. Like Chris said, this is an engineering plan. It's very tough to appreciate what the buffering and landscaping will look like. But you've got an all-star cast there with the architecture firm that will put a plan together that everybody can visualize and soften the impacts along Belmont, Main Street, and points north of the property. A lot of the existing vegetation on the property we're hoping to maintain as best as we can. We're not going to cut anything down that's necessary. There's a lot of existing buffering and vegetation on the property, and it's got a number of different varying elevations along the site. So there's a lot of work ahead of us to be done from an engineering standpoint, and certainly from a landscape and architectural standpoint. We have every intent of presenting those plans as the project continues to move forward. At this point, I welcome again any comments or questions that the board may have. Thank you.
Thanks. Just to facilitate the review going forward in anticipation of additional questions that will come up, probably internal circulation, parking, traffic, and then also the time frame relative to construction, which you said was 10 years, perhaps a conversation about how that type of phasing will impact the neighborhood with regard to construction. Something. Anything else before we go to the public? This is a public hearing. If there is anyone who wishes to speak, please come up to the mic and state your name for the record.
Just so everybody can help me out here, when you get up to the mic, could you please state your full name and spell your last for me? Thank you.
Brant White, B-R-A-N-T. So this development will impact me the most at the northern portion of the property. So I have concerns of construction, 10 years. It's going to impact me for 10 years. We have approval for Elderwood, I was told, as well, so that's going to impact me longer. There's 4.5 acres adjacent to this property. I'm not sure what's going on with that either. So this is additional things that are going to happen eventually. So that's 10 years of construction just for this. So those are things that we want to consider. When we move the driveway, unit 1, 2, 3, 4, will block water into wetlands. When that's blocked, my property will be flooded. A drainage pipe owned by the town on Highland with catch basins empties onto Kenwood Avenue, enters my property, enters Perry Avenue, the unpaved section, and then enters the development property. So when we put units 1, 2, 3, and 4 and stop the water flow, that's going to be a problem for me. Not sure what's going to happen there, or who's going to bail me out. Mr. Landry was incorrect. I have a lift unit on my property. I have a lift unit. Does a lift unit have to be put in to move all that sewer up the road? Because I'm on the low portion, so I have a lift unit. Every utility for the 4 or 5 houses go through the backyards. So water, my sewer goes through the backyard onto Highland. But no one else has sewer but me. So those are things that construction, that the water development, and moving the road, like I'm told prior to 2005, the property was filled in because the water used to flow through that property better. So it enters the ground on 571 Main Street and then to the pond. So it goes into the ground because that's been fixed or whatever. So those are concerns for myself and will continue to be concerns. Obstructing the water flow. There's no stop to that water out of that drainage pipe that's labeled You know, if we look at the prior plan and the prior file on the property, I've outlined the pipe number and everything like that. I've had the town engineer on the property years back. So, like, you know, the town tells me I can't direct water, but the town does it. The developers come in, because I don't want it on my property. The drainage pipe comes off of Kenwood and onto my property. But I can't stop that. I'm told I can't stop it. I can't bring in heavy equipment and move the water. But now we're going to have a developer do it. The town does it, but I can't. Trying to think of other. There's just so much that affects the property. The safety concerns, you know, as I've seen, when you enter Main Street from Belmont, when you enter Belmont from Perry, you know, the roads aren't wide enough. Perry's not wide enough, Belmont's not wide enough. When we have functions at the Elks, I'm not an Elks member, but I deal with the functions all the time. The roads are filled, it's a one-lane road at that time. So those are concerns. If you think of different holidays, it increases the traffic flow with those holidays. So that's a concern. I think the problem of thinking about the initial plan and the different things that the developer, like engineering plans, that was almost 10 years ago. So that's difficult to think about when you do the math of how many more people live in the town, that those things are still good. You know, when I listen to the neighbor, that he does drive down the street. I see his car. You know, he does drive by, but that's, you're not thinking about, as you said, looking at all the backs of those buildings on Belmont. That's pretty substantial there. But there's just so many things that are flawed on this. Perry Avenue, I don't think it's got enough space to pull that extra 20 feet, but I don't know. My house is set back a little ways, but those other houses are not. You know, I'm 53 there. You know, my house is set back a ways, but 45 is right on the road. You know, so the Elks parks on Perry when there's events. 29 is on the road. So it's not a lot of space that they're talking about pulling. And you can see perfectly there the wetland portion in green. You know, I have pictures, I've given pictures to the town, and it's in the file, and the water coming through those properties has not changed, it's only increased. So understand that the water comes down Kenwood, comes down Highland on two sides, and converges on those properties. So it's a lot of water. And it moves through. It moves through his property, and then goes on to a neighbor's, then back onto his property. But there's just to stop that water is going to be catastrophic for my house anyways. I'm sure there's more, but thank you very much.
Thank you.
Good evening. My name is Stephanie Osborne. It's been over 10 years, we've been coming to these meetings, keep getting changes, keep getting postponed, keep worrying about the anticipation of what's going to be in our backyards. I look back on the strategic planning of this town. I remember Barbara Hackey sitting at that desk and very concerned that this is the gateway to our town. I have a bed and breakfast a few houses over from Mr. Fiore. I think the idea of a B&B would be good. However, the other part of the development, I have a lot of concerns. First is the water, and I think Mr. White has explained his part of his concern. And for some of the new members in the file, in case you haven't seen, I'd really love you to take a good hard look at these photos that were taken years ago of what lands in my backyard and my new neighbor, Mr. Fusco, next door. We have water up to our knees and sometimes up to our waist. And it's usually a 100-year floodplain of rain, but now with what's happened over the years of climate changes, if we start taking away and eliminating the ground surface of grass or gravel and start putting more blacktop and more space of sites of different places where it's already soggy land in the back towards Perry Avenue, in some places along the back of the Elks, what is going to happen to that water? There is a big stone cistern there, and I understand from years and years ago that was one of our main water feeds to our town in South Kingston, where people used to take their horses and go get water. So there's a pretty good flow of water underneath that ground there that's still flowing. And whether there's springs there, I can't tell you, but something flows out to Perry, it flows out down through our yards, underneath the culvert, and down into Mr. Fiore's front land and down Main Street. So I know a lot of you know this, but I know new members or people who weren't here 10 years ago probably don't realize the catastrophic events that we can have with that water. Another issue that I really worry about is the higher you go with these buildings. They do look like a townhouse, and they do not blend in with the great gateway that this town has tried to preserve. You look at Shadow Farms, much larger scale, but look at what they did over there to try to blend at that park setting that was spoken about tonight. It was just done so everything blends, looks old, and everything is in character of that main house that was the main building there before they even did that development. So the higher you go, the more noise it penetrates. And I believe that they should be low-lying, they should be kind of subtle, they should be like a village instead of a townhouse. They shouldn't have any decks where people can sit out and yell and holler, and the noise just echoes through the rest of the neighborhood right now. If you go to our neighborhoods, Perry Avenue in the back of me, Main Street, except for the traffic during the day, you can hear a pin drop. I can hear Mr. Fiore talking over by his pool. And that's fine on you, Owen, but I can. So that's just to give you an idea of how quiet neighborhood that is, and it's going to change drastically. We all know they have a right to do what they like to do to a certain point, but I think we need to keep it as minimum as possible. We just had a house sale across the street from me for a price that would just knock you off the feet that you'd never expect in town here. Put probably over $1 million into it or more, and then we're going to have down the street up another 30 feet, townhouses that look like Warwick. Where there's you go down Route 117, that's all I can envision, and you see a beautiful Dutch colonial, and they're going to the right of that driveway, and they've lined them up like 2 rows of houses. It is the biggest eyesore that there is a better way to blend things in with the character of the town and the topography of the land. So, I could go on and on, but there's reason why I would rather see it go back to the first plan compared to this second plan that I think is just too obtrusive for that particular area. Thank you. But,
Thank you.
before
Are
I-
you submitting those?
Before I leave, no, I'm not going to submit them because they should be in your file. But I do believe some of these people who have not seen these really need to take a good look at this.
But, Madam Chair, if those are shown at this public hearing, they have to be left with the planning board. Madam Chair, if they're shown at this meeting, they need to be left.
I think can they be copied so that they could then be an exhibit submitted?
You should have them in your file. We've submitted these in the past, so I want to make sure that these, I'm not letting go of these are my originals, but you should have them in your file. And I would have hoped people would have looked at them before they came here this evening.
We want to make sure that
Yes.
it's consistent. Peter?
So I think just to have a clean record for this application for a change, what you could do is you could keep the originals for now, make reference to them, but if you wanted to just drop off another set of copies to the board.
Yes, and I'd be willing to bring the original so you make sure they match up, that I'm not pulling any wool over anybody's eyes. I've been on a board for 24 years. I know what happens, so I would be upfront to do that.
And just when you bring in copies, make sure you have a copy for the applicant can take a look at it too.
Sure.
Thank you. That would be appreciated.
Hi, I'm Ben DeFusco, last name D-E-F-U-S-C-O. I'm Italian, so we always have to spell our last name, so I'm used to that. I don't think I can really say anything in addition to what my neighbor Stephanie just said. A lot of those pictures are of my backyard, and I'll be happy to work with her to send those in. But I don't know how we go about approving a plan or a major change to a plan when it's just a bunch of boxes drawn on a piece of paper without any actual concept to what Mr. Fiore is actually going to do with those properties. You know, it's very tough to look at this and say, oh, well, conceptually we're going to change it and it's all going to be better, but we're not going to show you how this is really going to be better. So take the flooding and all the concerns that I have personally as the neighbor outside of it. I just don't think it's a very well-conceived plan when realistically, 10 years to get somewhere and then 4 additional years to get here, and now 6 months continuance on that, and, we don't have any real plan. So it just bothers me, I guess. So I have nothing really more to add to that than, would really like to see more of a plan.
Thank you.
Hi, my name is Katie Kiefer. That's spelled K-E-I-F-F-E-R. I reviewed those plans. I went into the town planning office and I read everything. I read all of the concerns that had been brought up. I could go through this whole list, but I think pretty much a lot of it was covered. But what confused me tonight was when we were looking at the plan, and the engineering firm stood up to talk about the plan. What I don't get is, if you're going to change the way those boxes are moved around on the plot, why would you not have to change the engineering to go with it? Like, I don't see how you can be running lines from the street and all of that stuff if you don't actually know where these units are going to be placed. So that was a big concern to me, and just Mr. DeFusco made an excellent point there, which is like, we don't actually know what the plan is, except that there's going to be 32 units, and, there's going to be some changes in roadways that don't seem to take into consideration some of the neighbors, but, whatever. The other thing I wanted to bring up is when you add a story to these units, the lighting from the lights from those buildings is going to be shining into everybody's windows who live near that development, right? So that would be my biggest objection if I were living right next door. It's like, I don't want to be seeing those lights all night long. I mean, I have friends who live in the Oaks, and they're, I'm blanking on the recovery home, the rehabilitation center right near that. But that was like a huge issue for them, was they had floodlights on all the time. Now, I don't know if you plan to have floodlights on in your parking lots, but you have a parking lot. So people are going to need lighting for that. And your neighbors are going to be the ones who are looking at that all night. So, there's all kinds of little questions like this that seem really important to how this is going to roll out that are just kind of, yeah, we're going to address that in another phase of the design, but it seems to me that that stuff has to be worked out now, not being presented with a plan in 6 months or another year that we heard what you said, and sorry, it doesn't work with our plan. That's all I have to say. Thank you.
Thank you.
My name's Justine Demetric, and I'm nervous as hell. I've never spoken.
I'm sorry.
Don't forget the spelling of your last name.
Oh, I am so sorry. How do we begin? Demetrick. I wrote something out, but then listening, some things came to my head. One was the point on the affordable housing. It never occurred to me in a million years that you could pay and get away from that. Okay, that's fine. But there's no mention of, since that deal went in decades ago or what have you, that's done dependent upon, I guess people would think of the market value at that time. So there's been no mention of if it costs $30,000 to build a house or whatever. When that was made, now that cost of that same to build those units is probably $250,000 to build. Which one? Who's responsible for that? Where does that number come from as to what they agreed upon? Not to screw you more, but it's just a value. Okay. That was one of them. And two, the last time you came up, the lawyer had said something about where we reduced the amount of homes, and that's better than us just tearing it all down. And that just seems kind of ready. But that happens all the time. I've been to 2 of these meetings, and I'm like, oh, that's a little sneaky thing. Anyway, I understand you're a developer. I know who you are and all that jazz, and I know developers love to develop, and I have no problem that you do develop. I guess I should just read this. I'd like to preface this with I was born here in the 70s, left in 88, returned in 2001. I've seen the transformation of the area, and I've traveled back roads all over this country, vacant towns to extremely wealthy communities, and I've seen what works for these communities and what doesn't as they change over the years. I'd also like to preface this with that I'm not anti-growth or housing. My family are in the building trades. My concern isn't against the development so much as against how it fits the location. This is the entrance to the town. Yes, the other half is now busier, but it's the formal older entrance. It sets the tone for the downtown. And I believe if you own a significant piece of property in a location such as this, you should have enough respect to build in a manner that it visually reflects this area. And I understand our town is growing, and we have a right to have it, I guess, grow to a certain degree. This is kind of important. Will you build the back of the lots to legal max? Will there be any proper setback? I guess that was kind of spoken of. Will the construction be boxy vinyl buildings with minimal amount of tiny windows allowed by code, looking like they belong in Florida or Vegas Platte? Will the old growth trees be eliminated? I know you try to save them, but I know there's ways you can cost a little more that you can actually save them. Just people don't. And replace with bare minimum vegetation. I see how Westerly has progressed, and I'm envious. I'm envious that they were able to keep the visual aesthetics in mixed-use spaces. While no one should be comfortable with it as a town center being owned by one or a few handful of people, I'm envious that the guy who did essentially buy up the town did it with a degree of respect to the surrounding community. This town's been very good to your family financially, and that's awesome. Kudos. And it's not against you. And none of this is just me. It's from other people I spoke to. But by shoving a bunch of buildings up along where the driveway is, it's gonna look like crap. Anyway, I kind of see it as a lack of respect for the town center and village, provided that the town's done well for you guys. The person who bought the property and restored it did a beautiful job, and you're so lucky to enjoy the privilege and the status of it. I'm not sure why you would want to ruin it by plunking ugly buildings on every spec you can get away with. Some of this is flow spot because I have to pass it all the time on my parents. I don't understand why you couldn't just turn the main building into your, I guess you're going to make it a B&B, keep the front totally the same, upmarket the heck out of them. Because we know there's a ton of money in the wealth that's moved into this area, and they will pay more for space. And that's something I learned by living in New York. You pay more the higher up you go because you've got less noise and less pollution. And seeing overdevelopment places and looking at real estate all over the country, the more space somebody has, the more you can ask, and the more it benefits everybody around you because you have more space, less pavement, and all of that sort of stuff. And I'm afraid that for people living by, if you do cram in things that look like, the development behind Tony's Pizza and things like this, it's going to devalue everybody around it. And if we're not careful, we'll look just like Warwick, Cranston, parts of North Kingstown and East Greenwich. They're soulless. Plunked in the middle of Main Street, we already have a bank that broke up the walkability of a retail street instead of the multi-use structure originally planned. But it's not it's nice that it's not a standard chain block dropped in, and it looks like it sort of belongs there, which is, I guess, a little bit of respect. But I feel when you have a prominent structure, ones that help define and help make how the community feels and communicates, you bear a degree of responsibility. So, thank you.
Thank you.
My name is Jim Opluch, O-P-A-L-U-C-H. So I agree with much of what I've heard today, and I won't repeat any of that. But when I look at this drawing here, I see you're going to have those, first of all, the most importantly, the 4 units that are in the extreme southeast part. Those are going to be 3 stories tall. That's going to dominate the view of what you see as you come down Main Street. And the other ones as well, but especially the ones closest to the road, they're closer than the house. They're going to look bigger than the original house. They're going to be 3 stories tall. And, again, it's going to dominate the view, I think. And, to a great extent, maybe a little lesser extent, that next 6 of them, and then to a lesser extent, the 4. The ones in the back, those are in the back, they won't really affect the overall view of the property as you're coming down Main Street. But these other ones, especially the ones up in the front, I think are going to just dominate the view of that property. And as it's been mentioned many times now, it's the gateway to the town. It's the old historic site. And so that I have a concern about that.
Thank you.
Stephanie Osborne again. I'd like to bring up one other point, too. Over the years, as these plans have come forward, there is always a major concern of the Elks. They have stake prizes. A lot of people know last Wednesday of every month for years and years and years. And there was great concern the last time a plan was kind of proposed at the very beginning of all the units abutting the very back of that property. So when all of a sudden the Elks start having their events and their functions, and it's really noisy over there, and the smoke starts coming in off the grill that's right up against the wall, and then all of a sudden the new occupants start complaining and start pounding on the Elks door, you better shut that steak fry down because we can't live with the smoke. I mean, it sounds kind of like a little ridiculous, but it's absolutely going to be a problem for them. So I just make you aware that I'm sure you all know the number of events that the Elks just hold, and that steak fry is one of their big fundraisers, and they've been doing it for 35, 40 years. And I would never want to see them shut down because of something like that.
Thank you.
Hi, Shirley Page, P-A-G-E. I wanted to just say a few things positive, and I agree with some of the things that people are saying here tonight. Water is always an issue. I don't live on Belmont or Perry or Main, but I live on Wright Avenue, which is just the other side of the old Rochwood Inn. We talk about walls and buildings, what people have to look at, the gateway to Wakefield. I put a lot of that responsibility on the town, for the way that it is zoned and what is allowed in our zoning. If we really want our town to remain quaint and beautiful and enjoyable for tourists who come here seasonally, those are things that the town needs to consider. They need to have a vision. I've lived in town for 34 years, even longer now. I've never really seen a vision. We have more banks than most towns do. I don't think the town has the vision that we need to have. As far as this particular project, I admire the fact that if Rolly's going to have a bed and breakfast in the main house, that he's going to be an on-site owner. I think that is a massive undertaking for the town to absorb that thought that if we do have these kinds of projects going on, having an on-site owner speaks volumes. He's not going to want to live in a place that's not going to be beautiful. These do look like boxes right now. I think there's a big responsibility on the architect as they build these or design these to create them in a way that they're possibly staggered in height, have porches that face the street, do the things that architecturally will make the neighborhood continue to feel like a neighborhood. I have a respect for people who own property in town and want to utilize that property and have the opportunity to do that the way we are zoned in Wakefield and South Kingstown. And I have a passion for a lot of what people have today with respect to affordable housing. That being said, if there was an agreement made early on, that agreement should remain. There are ways that that money could be used to give to Habitat for Humanity to build that affordable housing in and around South Kingstown and Wakefield. If they allowed that to happen, then it's already happened. If it's etched in granite, fine. But that money could be used, and Habitat for Humanity is probably somebody that could be able to use that money. Land, of course, is always a consideration. Where do we build those homes? Again, the town needs to be thinking about that. Having land here and there to allow affordable housing or building of that nature. Possibly reducing our lots for multiple family homes in our area so that people can expand their homes and create two-family homes out of one-family homes. That's a great way to increase affordable housing in our area. So I put a lot of my considerations on the town and the way that they think and how possibly having these kinds of formats would be very important going forward for a project like this and other projects in the future where you incorporate people in town that do have vision, that do have foresight, that understand real estate, understand people's needs, and want to protect their properties. I'm going to be looking at a wall. If that Alzheimer's Center goes up on the Lockwood Inn property, I'm going to be looking at 40 feet of three-story wall from where I live on Wright Avenue. So I do understand the concerns of these people. And if it is the gateway, let's consider that, and let's consider South Kingstown as a whole and how we want it to be and what we want it to look like. And another thing I'd just like to bring to the table has nothing to do with this project, but has to do with our town, is that we have had a huge transition over the last 3 or 4 years, and a lot of our homeowners today are only going to be here for 3 months out of the year. They're not going to be here year-round. That's not supporting our businesses at all. We need to have community again within the realm of South Kingstown. And I don't know how you want to propose that, but I think it's consideration for the town and for our boards. Thank you.
Thank you. Is there anyone who wishes to speak? Are there any further comments from board members at this time?
I'll go. And I apologize for being somewhat redundant to what I already said, but I think everybody in this room appreciates how beautiful an area that is. Everybody, I think, is appreciative of how beautiful Sugarloaf Hill is. And this property defines a lot of that. This property's been here for a really long time, and it defines a good part of the community. The truth of the matter is 30 or 40 years, very few of us are going to be here, if any of us. But that property is going to be there. And that property is going to be there 100 years from now. And I think the applicant has property rights. We're not really here to consider whether 32 is the right number or not. He's better prove that. We're here to just consider whether this proposal is a better plan. Personally, I would like to see the applicant take more time, and I don't know how other members feel, but I would give more than a 6-month extension. If that time was used to do a design that makes that look like that was all built at the same time, that that was all planned at the same time, that that was a park-like setting that continues the beauty of Sugarloaf Hill. I do think that what we have here, especially with the latest plan, maybe less so with the first one, is something that just looks like we took a beautiful old property and we stuck houses on there because we could make a profit. I mean, I think the applicant has done a lot for this town. I appreciate that. But the truth of the matter is this is going to be part of your legacy. And I know you have some other legacies too. And we're going to look back, people look back 50 years from now and they're going to see that. I would like to see the applicant take more time and give us a plan that really integrates this as a park. With that said, if it's choices between the two that's in front of us, I think the first one is a little bit better designed than the second. So that's where I stand.
Thanks, Joe. Anyone else? Thoughts before we have a motion to continue this to a date certain? I think I want to thank everyone for coming out tonight. We appreciate hearing from folks. I agree with the comments of my fellow board members. Moving forward, there is opportunity for allowing this design to evolve, and the planning department has some very good books in their library. If you wish to take into consideration some alternative type designs, or again, making this better as we move along. As the applicant knows, it's always a process. It involves a negotiation, listening to the public, listening to the board, which ultimately can result in a better design. Susan?
I know that it's not always easy to stand up in front of the meeting, and I think that we appreciate all of your thoughts that you've brought to us tonight. One of the things that ties our hands is that we don't have legislation in this town that we can help design what these buildings look like. It's not in our regulations. We are, unfortunately, needing to accept whatever's brought before us. And the only way that we in town will have rules that we can help keep things looking beautiful with our standards is if folks in town ask for that change. That if you all demand that we create design standards for projects like this, we'll have more freedom to be able to make sure they look like you want them to look. And so I don't know where the step is. I don't know if we're asking you to call poor Jamie or the town council or how to do that, but the only way that we can have the power to make sure this looks the way you want it to look is if you tell them to give us that authority. So I implore you that if that's important to you, that's where our hands are tied. But you all have the power to help us have the power to make that change. So thank you.
Anything else from board members? Paper?
I also want to thank you for coming and for sharing your thoughts with us. And I think that the public hearing is a vital forum, and I think that having the applicant here listen to everything, and I can tell that He's been very attentive, and all of your comments have been heard and appreciated, so thank you all.
Motion to continue this to a date certain?
Madam Chair, before you entertain that motion,
Sure.
as you're aware, you need to time date certain. So your next regularly scheduled meeting is October 22nd. Your next regularly scheduled meeting after that is November 26th. So I know you have this on a special night. If it's your intent to do that again, we may recommend that you continue this to date certain to the 22nd. Allow us to look at calendars and the availability of the applicant as well as the planning board to see if there's an alternative date to your November 26th meeting.
If that helps, Madam Chair, I have something on October 22nd, so I'll be here anyway, if that helps render a decision, but to the extent that a special meeting is needed, I leave that to the discretion of the board on where this fits in.
You know, and as discussed earlier this evening, we have time. So if there is not any new information, then obviously you can ask for a continuance. So, Jamie, it's hard for us to look in a crystal ball and know what we have coming forward on the 22nd.
I did discuss that matter with Jay. Jay, if you want to opine a little bit of what our agenda looks like on the 22nd, but I think you mentioned the potential Fieldstone.
If I recall correctly, there are 3 items, zoning map amendment, and a few other, not in Columbia, a few other applications. I don't know if it would behoove the board or the applicant to continue to avoid our regular sessions. I think it might be the time to just get on the regular session and we just try to process it like we do with all the other applications.
So are you saying yes for October or better to go to the November meeting?
I think we could handle it in October.
Okay.
Yeah, what I'm hearing from Jay is October 22nd could be appropriate.
I think this would be maybe the 4th agenda item, possibly the 5th, but I don't see the other agenda items being exceptionally large.
Okay. So we had a motion from Joe. Did we have a second on this? Second from Peter to continue to the October 22nd meeting. Any further discussion? Hearing none, all those in favor say aye. Aye. Motion carries. Thank you, everyone.
Again, Madam Chair, for clarity, that'd be October 22nd in the Town Council chambers, starting the meeting at 6:30.
Yes.
Thank you.
Our next, actually, we normally take a break at now 8:30, so we'll take a 5-minute break and then come back and finish up the items on the agenda. Last few agenda items, we don't have anything with land use regulatory matters. Planning board, liaison activities, anything briefly from anybody?
Yeah, so the last Affordable Housing Commission meeting was largely dedicated to reviewing the survey for the boards and commissions for the housing initiative workshops.
Which we need to do that at our next work session. The Route 1 Scenic Stewardship Plan is moving along. We are going to be wrapping it up hopefully within 6 months. The only other thing worth noting is that the consultant for the Old Tower Hill Road project, Able City, will be coming up from Florida on the 28th of this month to meet with the town council as part of their meeting. That's all I have. Jamie?
Yeah, potentially on the 28th, in addition to Able City East, Union Studios may also be doing their presentation to the council on the 3 town-controlled properties as it relates to affordable housing initiatives. Again, if you can put that on your radar, that may be a good meeting either to attend or at least watch live on TV that night.
Anything else, Jamie, other than working together with legal to finish what we need to do for regulatory compliance with the...
Just on our side, it may seem a long ways away, but we've already started the budgeting process for next fiscal year. Okay. So we just did our capital improvement request. Again, we had funding requirements in 2025, 2026, 2027 for some updates to regulations. So I think we're at total request for the 6 years is around $450,000. We're at like 150, 100, 75, and then 25, 25, 25. Wanes down in the later years. We're trying to upload some stuff to continue the momentum we have with some of our studies that will relate to regulatory changes.
Are you allowed to talk about the new staff person that will be
that is still being discussed.
Okay. All right, if there's nothing else, motion to adjourn? Motion from Peter, second. Second from Caper. All those in favor say, oh, before that, TRC? I don't know where we are because this is a special meeting, so I don't know if we're off by.
We can pick a TRC meeting on the 22nd, can't we, Representative?
Okay, we'll do it then. All right, all those in favor say aye. Aye, motion carries. Meeting adjourned.